Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. In today's video, we will explore a very important question under Indian criminal jurisprudence. Can two court cases be filed for one incident? We'll discuss this topic in depth with the help of landmark Supreme Court judgments, constitutional provisions, and practical implications, essential for every lawyer, law student, and common citizen to understand. 1. Introduction. When we talk about two court cases for one incident, it generally refers to a single event or transaction, for example, one fight, one road accident, or one confrontation, followed by two separate sets of legal proceedings, such as two FIR or two prosecutions, both arising out of that same occurrence. This issue is extremely important because it involves the rights of the accused, ensuring they are not harassed through multiple prosecutions for the same act, the efficiency of the criminal justice system by avoiding duplication and misuse of process, and the constitutional principles of fairness, equality before law, and personal liberty under Articles 14, 20, 2, and 21 of the Constitution of India. Article 22 specifically guarantees that no person shall be prosecuted and punished for the same offence more than once. This is known as the doctrine of double jeopardy. However, the real challenge lies in determining whether two proceedings actually arise from the same incident or transaction. Let's understand this through two landmark Supreme Court cases. 2. Landmark Case 1 T. Antony v. State of Kerala, 2001, 6 SCC 181. Facts. In Kannur district, Kerala, 5 persons were killed and 6 others injured in police firing. 2 FIR, crime number 353/94 and crime number 354/94 were registered for the same incident. Later, another FIR, crime number 268/97, was again filed for the same occurrence. Issue: whether a second FIR can be registered for the same cognizable offence or same transaction already covered by an earlier FIR under the Code of Criminal Procedure, 1973, CRPC, now replaced by the Bharatiya Nagrik Suraksha Sanhita, 2023, BNSS, effective from 1 July 2024. Decision ratio. The Supreme Court held that once information about a cognizable offence has been recorded and investigation commenced, a second FIR in respect of the same occurrence is not permissible under law. The court clarified that any subsequent information about the same incident should be treated as part of the same investigation under Section 173(8) CRPC, now corresponding provision under BNSS 2023. The court further emphasized, if the second FIR is based on the same transaction or occurrence, it would amount to harassment of the accused and a violation of his fundamental rights under Article 21 of the Constitution. Practical implication. If a new FIR is registered for the same event, the accused can seek quashing under Section 482 CRPC, now corresponding section under BNSS 2023, relying on this precedent. Investigating officers should proceed through a supplementary investigation report under Section 173(8) rather than registering a new FIR. Citation: T. Antony v. State of Kerala, 2001, 6 SCC 181, AIR 2001 SC 2637. 3. Clarificatory case Amit Bhai Anilchandra Shah v. CBI, 2013, 6 SCC 348. Facts. This case arose from the Sohrabuddin encounter investigation. The CBI registered a fresh FIR, RC3, S. 2011, even though an earlier FIR and charge sheet had already covered the same alleged conspiracy. Issue: whether registration of this fresh FIR by CBI was legally permissible, despite an earlier FIR already dealing with the same conspiracy or transaction under the then operative CRPC, now replaced by BNSS 2023. Decision ratio. The Supreme Court reaffirmed T. Antony and held the second FIR was not based on a distinct transaction, it was part of the same conspiracy and same occurrence. Therefore, it should have been treated as part of the earlier investigation and not as a new case. However, the court also laid down an important exception. If new facts come to light disclosing a new and distinct offence involving different victims or a separate transaction, a subsequent FIR may be legally permissible. The court introduced the test of sameness. If both FIR relate to the same incident, same parties, and same facts, the second FIR is barred. If they concern distinct facts or victims, the second FIR may stand. Practical implication. Investigating agencies must carefully assess whether a new FIR introduces genuinely fresh facts or distinct offences. Defense counsel should always compare both FIR to apply the test of sameness. If both arise from the same facts, a quashing petition will likely succeed. Citation: Amit Bhai Anilchandra Shah vs. CBI and another, 2013, 6 SCC 348. 4 legal principles summarized. A. Single transaction principle. Once an FIR is registered and investigation begins under the old CRPC, now BNSS 2023, a second FIR for the same incident or transaction is not permissible. T. Antony, 2001. B. Test of sameness. If both FIR relate to identical facts, parties, or occurrences, the second FIR is invalid. If they relate to distinct transactions, offences, or victims, it may be allowed. C. Exceptions. A second FIR may be justified only when a new or distinct offence is disclosed, a different victim or complainant is involved, fresh facts emerge that were not part of the earlier investigation. D. Civil versus criminal proceedings. A civil proceeding for compensation or damages and a criminal prosecution for the offence can continue simultaneously for the same incident. They address different legal rights, and the criminal procedure under CRPC BNSS does not bar civil remedies. E. Constitutional safeguards. These principles rest on Articles 14, 20, 2, and 21, ensuring that no citizen is harassed or punished twice for the same cause. 5 practical guidance for lawyers and litigants. Examine the first FIR carefully, note offences, parties, and event description under CRPC or BNSS, depending on the date. Before filing or opposing a second FIR, ask: are the offences identical under the same statute, IPC BNS? Do both FIR arise from the same facts? Is there any new transaction or victim involved? If both FIR arise from the same event, file a quashing petition under Section 482 CRPC or equivalent BNSS provision. Keep proper records, FIR copies, charge sheets, and investigation reports to establish sameness or difference. Remember, civil remedies are not barred. Civil and criminal actions can coexist. Advise clients that multiple criminal FIR for the same event are generally invalid, but civil plus criminal cases may proceed together legitimately. 6 illustrative examples. Example 1: road accident. If a driver causes an accident injuring another person. 1 criminal case under Sections 279 by 337 IPC, now BNS, 2023. Another civil case for compensation under the Motor Vehicles Act. Both are permissible, different legal remedies. Example 2: same offence, 2 FIR. If after 1 road accident, 2 FIR are registered narrating identical facts under the CRPC BNS framework, the second FIR is not permissible, as per T. Antony. Example 3: new facts or victims. If new evidence reveals another accused or a new victim not covered earlier, leading to a distinct offence, a second FIR may be valid. 7 conclusion. To summarize, a second FIR for the same incident or transaction is generally barred, as held in T. Antony vs. State of Kerala. The Supreme Court in Amit Bhai Shah clarified that a new FIR is valid only for distinct facts, offences, or victims. The guiding principle is the test of sameness. Civil and criminal remedies can coexist, but duplicate criminal prosecutions cannot. Remember, from 1st July 2024, India's criminal justice system operates under the new laws. Bharatiya Nyaya Sanhita, 2023, BNS, replacing the Indian Penal Code. Bharatiya Nagrik Suraksha Sanhita, 2023, BNSS, replacing the Code of Criminal Procedure. Bharatiya Sakshya Adhiniyam, 2023, BSA, replacing the Indian Evidence Act. When citing older judgments, always clarify whether the case falls under the old law or the new law. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind! Jai Bharat!